5 seconds to go. Start. Save as otherwise provided in clause A. No pregnancy shall be terminated except with the consent of the pregnant women. Section 3 provides that registered medical practitioners shall not be guilty of committing any offence under the Indian Penal Code 1860 or under any other law for the time being in force if they terminate pregnancies in accordance with the MTP Act. Subsection 4 of Section 3 stipulates that a pregnancy shall not be terminated except with the consent of the pregnant woman and if the woman is below 18 years of age or is mentally ill with the consent of her guardian. Subject to the requirement contained in subsection 4 of section 3, subsection 2 of section 3 provides that a pregnancy may be terminated by a registered medical practitioner subject to the conditions laid down therein. Pregnancies may be terminated where they do not exceed 20 weeks and for certain categories of women where they do not exceed 24 weeks. Section 32A of the MTP Act permits the termination of a pregnancy where the length of the pregnancy does not exceed 20 weeks. Section 32B of MTP Act permits the termination of a pregnancy where the length of the pregnancy is between 20 and 24 weeks of such categories of women as may be prescribed by rules. These pregnancies under Section 3 may be terminated if the medical practitioner in question or in the case of pregnancies between 20 and 24 weeks, not less than 2 registered medical practitioners is in good faith of the opinion that the continuance of the pregnancy would put the pregnant woman's life at risk. The continuance of the pregnancy would involve grave danger to the pregnant woman's physical health. The continuance of the pregnancy would involve grave danger to the pregnant woman's mental health. There is a substantial risk that the child would suffer from a serious physical or mental abnormality if it is born. In determining whether the continuation of the pregnancy would involve grave danger to the pregnant woman's physical or mental health, her actual or reasonably foreseeable environment may be taken into account. We are of the opinion that significant reliance ought to be placed on each woman's own estimation of whether she is in a position to continue and carry to term her pregnancy. The explanations to Section 3.2 provide for two legal presumptions indicating what constitutes a grave injury to the pregnant woman's mental health. Explanation 1 stipulates that pregnancy which occur due to the failure of a contraceptive device or method used by a woman or her partner for limiting the number of children or preventing pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman if the pregnancy has not exceeded 20 weeks. A similar legal presumption is provided for in explanation 2, which stipulates that where a woman alleges that a pregnancy was caused as a consequence of rape, the anguish caused by the pregnancy shall be presumed to constitute a grave injury to her mental health. The legal presumption in explanation 2 is applicable to all pregnancies which have not exceeded 24 weeks. Stop.